Hi, my name is Mark D. Copoulos, and I'm a Philadelphia criminal defense and real estate lawyer. And today I would like to talk a little bit about petitions to open in the state of Pennsylvania, and specifically the county of Philadelphia where I practice. Every year there's thousands and thousands of cases that are resolved by way of a default judgment. And effectively what that is it means that one side shows up to court, the other side fails to show up to court, and because the other side fails to show up to court, they effectively lose their case by default. A default judgment is taken without hearing the merits of the case, and the plaintiff, if the plaintiff is the person taking the judgment, gets effectively everything that they were asking for. So for example, in a landlord-tenant case, the landlord goes in, the defendant tenant is not there. The landlord may ask for a money judgment for all the rent that they say is due, for utility bills, for property damages, and everything else, and it won't be closely scrutinized because the defendant's not there. So for example, the plaintiff, let's say, takes a default judgment for $18,000 in possession of the property. The defendant tenant hasn't had an opportunity to present their case. The courts have a mechanism called a petition to open default judgment, which is effectively a chance for a defendant to ask the court to consider reopening the case after a default judgment's been taken. And there's effectively three prongs to the petition to open a default judgment. The first prong is, was the petition timely filed? For example, did the defendant come into court 15 minutes late, and once they see the judgment's been taken, they immediately go up and file the petition? Or is this a petition that's filed months or even years after the money judgment was taken? The courts will consider timeliness. The second factor that the courts will consider is whether there was a meritorious defense to the case. Kind of going back to our hypothetical there for the $18,000 money judgment, a landlord-tenant case, if the defendant can show, for example, that the property wasn't habitable, or there were open L&I violations, or there's a big hole in the roof, or maybe they slipped and fell and there was pending litigation, and so they were withholding the rent for a meritorious reason, and they have a good, strong defense to the case, the court may consider that in opening the default judgment and giving the defendant another chance to present their case. The third factor that the court looks at in deciding whether or not to open a petition, whether or not to open a default judgment, is the reason for the failure to appear. So if you're a defendant, you missed court because you were in the hospital because you had a health condition, that's probably going to be viewed as much more compelling than you missed an Uber to the courthouse and you were a little bit late because you didn't schedule your time correctly. So the courts will also look at, why did you miss court? So loosely stated, that is a three-factor test for a petition to open default judgment. One, why'd you fail to appear? Two, do you have a meritorious defense? And three, how quickly was that petition filed in relation to when the judgment was entered? Generally, the courts have said that if the petition is filed within 30 days of the judgment being entered, that's considered a timely petition, and then they'll look to the other two prongs of the test. So loosely stated, that's the test. The court is also often going to look at service. So for example, if you're a defendant and you didn't know about the court date because you weren't served with the complaint, that's almost an automatic situation where the court is going to grant a default judgment and open a default judgment. If you're a defendant and you were served with a complaint and you just missed court, then that's when the court's really going to kind of go to that three-factor test, and it's probably going to be more of an uphill battle. My name is Mark D. Copoulos. I'm a Philadelphia criminal defense and real estate lawyer. If a judgment has been entered against you in civil court, if you're a tenant and a default judgment was entered, or if you're in a civil case and a default judgment was entered for failure to answer the complaint, call our office to discuss filing a petition to open default judgment. Like I said, it's a three-factor test, and you're going to have an opportunity at least to ask the court to give you another chance. Generally speaking, the courts disfavor default judgments. And if you look at the case law, they disfavor default judgments because the idea behind any just system is that both parties should have an opportunity to be heard and to present their case. And if a default's taken, like I kind of discussed in this earlier analogy, the court is not going to scrutinize necessarily the damages. So that $18,500 money judgment is entered. We don't know anything about the other circumstances of the case. We don't know anything about whether the defendant may have had a reason to withhold their rent. The court is just granting it based on the pleadings. The courts don't like that. They like to hear both sides present their case. So if you have an argument, if you have a defense, and you just missed court and you have a good reason, a good explanation for why you did, speak with an attorney about filing a petition to open default judgment. And it's not always going to be a guarantee that the petition is granted. The courts have recently, perhaps because of the backlog, started construing these petitions a little bit more stringently than they did in the past, but it's definitely worth putting it in if a default judgment's been entered against you. My name is Mark D. Copoulos. I'm a Philadelphia criminal defense and real estate lawyer. And if you need to file a petition to open default judgment, or if you have any civil real estate questions, feel free to give us our office a call at 267-535-9776. Thank you and have a great day.